My life was changed forever when you chose to sexually assault me 100 yards from the school I attended.
As we back up, this is when he pulls the gun out, when he's backed up against the bar.
Nobody searched for her like her dad, Tommy Ballard. And he searched for her every day, every night, until the day he died.
In December 2017, Mark Lysak carried out a deadly attack in Collingswood, New Jersey, killing his ex-girlfriend and her sister while severely injuring a third woman. The brutal nature of the crime led to a swift indictment in 2018, when a Camden County grand jury charged him with multiple counts, including 2 counts of first-degree murder, attempted murder, and aggravated assault. Rather than face trial, Lysak accepted a plea deal in 2019, pleading guilty to 2 murders and 1 aggravated assault charge. In return, prosecutors dismissed the remaining counts.
He is facing potentially 2 consecutive life sentences, in addition to a 3rd sentence consecutive of up to 20 years state prison subject to the No Early Release Act. He is facing about as much time in prison as a criminal defendant can face.
In South Jersey his whole life. And his family does also reside here. He has both a mother and a brother and a sister who have been to court in the past for him. They're not present here today. For emotional reasons, they thought it might be difficult, but they are supportive. In fact, would allow Mr. Lysak to reside with them if the court were so inclined.
Law enforcement officers are reporting to the scene of a disturbance allegedly observed. The defendant on top of the victim, who's the alleged victim of the attempted murder, holding the weapon that's allegedly the murder weapon. There's a statement from the surviving witness. For all those reasons, I find the state has met its burden of establishing by clear and convincing evidence that there's no set of conditions that would reasonably assure the defendant's appearance in court or the safety and protection of any other person or of the community.
He was sentenced to a 47-year prison term under New Jersey's No Early Release Act, making him ineligible for parole. Years later, Lysak attempted to overturn his sentence through a post-conviction relief PCR petition, arguing that his defense attorney had misled him by failing to share key evidence, such as grand jury minutes and autopsy reports. However, in June 2025, the appellate court rejected his claims, stating that even if there were deficiencies in his legal representation, Lysak failed to prove that the outcome of the case would have been different. With this decision, his sentence remains intact, and no evidentiary hearing will be held. In June 2024, a disturbing investigation in Claremont County, Ohio, began after video evidence surfaced during a sexual battery probe involving Charles Edmondson. The footage revealed that 5 adopted boys and girls with special needs were being kept in confined, basement-like conditions inside the Edmondson home. Prosecutors described the living environment as worse than what prisoners of war endure. Following this discovery, both Charles and Matthew Edmondson were indicted on multiple charges of child endangerment and abuse. Reports later uncovered additional details of injuries, leading to a second indictment in July. Alongside them, Matthew's 20-year-old biological son, Bailey Edmondson, was also charged for his role in the mistreatment, with neighbors reporting that Bailey and Matthew were often seen as the primary caregivers.
Those were the 2 that were always with the kids. If it was Matt and the kids, Bailey was right there. I can't say that there wasn't arguments in this house, because there was. There was screaming, normal neighbor stuff, nothing that would make you question otherwise what was going on inside that home. Who's guilty? What happened? And when are we going to find out?
How bad and long has this really been going on?
I just think Bailey was an innocent child that was raised in a situation that nobody should ever have to endure. I think the trauma started way before these 5 children. And I think that it had to do with Bailey.
By December 2024, all 3 reached plea agreements.
It's hard not knowing the truth of what happened and how deep it actually goes and how much we feel for the kids and that were involved.
Matthew Edmondson pleaded guilty to 5 counts of child endangerment and was sentenced to 13 years in prison. Charles Edmondson was admitted to kidnapping, felonious assault, and multiple child endangerment charges, receiving a 15-year sentence. Bailey Edmondson accepted a plea to misdemeanor endangerment and was sentenced to 2 years of probation. The boys and girls were removed from the home and placed into safer environments, where they are now reportedly recovering well. In a groundbreaking case out of Broward County, Florida, Miguel Albizu, owner of a wedding venue in Southwest Ranches, faced 9 counts of aggravated assault with a deadly weapon after an altercation during a 2023 wedding event. According to the defense, the incident escalated when intoxicated guests became aggressive, allegedly injuring Albizu's wife and a party planner. Albizu testified that he woke up to the chaos and acted to protect his family and others, drawing his weapon only when he was cornered near a bar by advancing individuals. He sought protection under Florida's Stand Your Ground law, which allows the use of force if someone reasonably believes it's necessary to prevent harm. During the pretrial immunity hearing in December 2024, Albizu's legal team introduced a first-of-its-kind approach in Florida, virtual reality evidence. Broward County Judge Andrew Siegel wore a VR headset to experience an immersive 3D reconstruction of the scene, viewed from Albizu's perspective.
These people are coming into his space, right?
And he's backing up.
And he's backing
So
up.
as not to be injured like his wife. As we back up and are being approached, and it's like a chest-to-chest encounter, no matter where you look. Now, this is where the vase was broken from the chair that had been thrown previous.
And this is actually a photograph from one of the videos, right?
Yes, that's correct. And there's the names.
And the purpose of putting in this photograph is to show what connection to this animation.
That's correct.
The simulation, created by a forensic expert based on depositions, police reports, and a site visit, aimed to help the judge understand the spatial dynamics and threat level Albizu claimed to face.
And right in his personal space, he still has not brought out his
That is correct.
physical size difference, the age difference, and then he's grabbed.
This is when he pulls the when he's backed up against the bar.
The use of VR in a courtroom setting was hailed as potentially historic, not just for Florida, but possibly for the entire country. The hearing continues, and if immunity is denied, the case will proceed to a jury trial, where the admissibility of virtual reality evidence will again come under legal scrutiny. In 1997, a boy was attacked while walking near a wooded area in Brooklyn, Ohio. He bravely reported the assault, and police collected DNA evidence, though no suspect was matched at the time. The case remained open, with prosecutors indicting the unknown assailant under the name John Doe to preserve the charges. More than 2 decades later, in 2021, investigators submitted the DNA to a genealogical database, leading to a breakthrough. Through advanced forensic technology and genealogy, the profile was matched to Dennis Gribble, now in his 70s, who was eventually identified and arrested.
BCI and the hard work their scientists did in obtaining this DNA and getting a profile that allowed us to do genealogy.
On May 4th, 2023, 73-year-old Gribble pleaded guilty in Cuyahoga County Common Pleas Court. The victim, now an adult, faced Gribble in court and described how the trauma had shaped his life.
My life was changed forever when you chose to sexually assault me 100 yards from the school I attended and had to keep going for the next 6 years.
Prosecutors revealed Gribble's disturbing pattern of offenses against young boys dating as far back as 1969.
It's not often you hear a defendant admit that he still suffers from violent urges to sexually assault young children and admit, frankly, on the record, that that's been his whole pattern in life. Nothing excuses repeatedly assaulting young boys throughout our community.
Judge Timothy McCormick sentenced him to the maximum 10 years in prison, ordered lifetime sex offender registration, and imposed 5 years of supervised release. The case, which remained unsolved for 26 years, finally closed with justice delivered thanks to perseverance and modern DNA technology. What began as a routine pizza delivery in Kissimmee, Florida, quickly spiraled into a violent crime. On the evening of December 22, 2024, 22-year-old Brianna Alvalo delivered a $33 order to a family staying at the Riviera Motel. After receiving only a $2 tip, Alvalo reportedly became visibly upset and left the scene. Roughly an hour later, she returned in the same red Toyota Camry, this time accompanied by a masked man armed with a weapon. Together, they forced their way into the motel room, where Alvalo attacked 29-year-old Melinda Irizarry, a pregnant mother, while her daughter watched in horror. Irizarry, though critically wounded, survived after emergency surgery. Authorities later confirmed that the motive behind the attack was Alvalo's anger over the small tip. Alvalo was arrested the following day and charged with attempted murder, home invasion with a firearm, kidnapping, and aggravated assault.
Good morning, ma'am. Please state your name.
Brianna Alvaro.
I do find that there is probable cause.
Believes that this is a punishable by life offense. There should be no bond set, and it should not be set for a pretrial detention hearing.
She is being held without bond while the search continues for her armed accomplice. The case has shocked the community, serving as a chilling reminder of how a trivial dispute can escalate into life-threatening violence. Tyquan Kelly's legal troubles began in March 2023 when he was arrested for possessing marijuana and a firearm while leaving a suspected drug house. He was released on a $3,500 bond. Just weeks later, on April 16th, he faced new charges, assault and battery, along with possession of a weapon, yet again securing release, this time on a $50,000 bond. The situation escalated on April 29th during a mass at Meadow Lake Park in Columbia, South Carolina, which left 11 people injured. Though not charged for the itself, Kelly was seen discarding a firearm from a fleeing vehicle. He was arrested hours later on drug and weapons charges and released once more, this time on a $10,000 bond. His repeated releases raised serious alarms with prosecutors and law enforcement.
He's been arrested 3 times, 7 different charges. He's got a gun every time. He's proven that he gets out on bond and continues to commit crimes. He's now been associated with a very violent and dangerous incident. Wherever he goes, crime follows.
Citing the rapid string of arrests and Kelly's repeated involvement with firearms, the solicitor's office requested a bond revocation hearing.
None of these are convictions, and in fact, he does not have any convictions on his record.
He's not a child. And I just want him to be home with us. I'm asking him if he can just be home in the house and not go nowhere.
On May 3rd, 2023, Circuit Judge Robert Hood ruled to revoke Kelly's bond, labeling him a public threat.
All right, at this point in time, Mr. Kelly, I am going to go ahead and revoke your bond. I find that you are a danger to the community.
What else can we do except keep him in jail because he's already showed he's a danger to the community?
The judge allowed the issue to be revisited after 90 days. Kelly's legal troubles didn't end there. By February 2025, he was once again in court after being involved in another shooting incident in Forest Acres. A probation violation hearing confirmed he had breached prior sentencing terms, and he was ordered to serve the remainder of a 5-year prison sentence. In February 2018, inmate Joshua Castleberry suffered serious injuries at the Cuyahoga County Jail after what began as a dispute over a moldy sandwich. According to Castleberry's testimony, he requested a replacement after receiving spoiled food, but the situation escalated when he swore at a corrections officer. He claimed Officer John Wilson responded with excessive force. The incident left Castleberry with severe injuries, requiring surgical treatment.
Then he takes me by my hair, bangs my head on the floor several times. It was like an instant pain, like on a scale of 1 to 10, it was a 10. I don't know, I just remember my head just bouncing.
Body camera footage captured only the aftermath, showing Castleberry injured and restrained with a spit hood over his head. But there was no video from inside the cell where the alleged assault took place. During the trial, prosecutors argued that Wilson assaulted Castleberry, while Officer Jason Joswiak denied him timely medical care by preventing a nurse from responding immediately. The defense maintained that Castleberry was combative and that the officers acted within policy. Without clear video evidence of the actual moment of force, the jury struggled to reach a unanimous decision. The trial ended in a mistrial, making it the first of several jail-related abuse cases in Cuyahoga County to go to court amid a broader investigation into inmate mistreatment. In August 2016, Sydney Saffold, a Cleveland attorney and daughter of Judge Shirley Strickland Saffold, was arrested following a domestic incident at her mother's home in Bratenahl, Ohio. Police were called after an altercation reportedly turned physical, with Sydney accused of striking her mother during an argument. Despite the accusation, it was Sydney who called 911 and waited for police outside the home. Officers noted she appeared intoxicated at the time of the incident. The following day, Sydney appeared in Cleveland Municipal Court, where she pleaded not guilty to a domestic violence charge.
The purpose of bond is twofold. It's number one, to ensure appearance, and number two, to prevent future crimes. Dealing with future appearance, this young lady is a graduate of Ohio State University, the University of Cincinnati School of Law. She practices law in this building every day. She's a lawyer in my office. She has a small child that she raises on her own. There's no chance of flight. When we look at threat to the community, the alleged victim in this case is one of the most powerful people in the county. I'm sure she can take care of herself, but I do have the police report from Bratenahl, and if you'd like to have it, what it does reflect is that Sydney's the one who called police. Sydney was out waiting for police. There was no indication that she was going to flee. What she wanted to do was go inside and get her keys. So if she was, even at that moment, no injuries whatsoever to the alleged victim, if she had any idea of harming her, even seconds after this occurred, she wasn't going to do it. So I think there's, none of those things are there. There's nothing, no risk here. Obviously, this is her mother. Her brother's in Florida right now. Her father's elderly, would be the only person who can pay bond, and he's on his way by the time that that's necessary.
Judge, the city would just ask for you to take into account the nature of the allegations, and then we leave it to the court to decide the bond.
Her defense highlighted that she is a practicing attorney, a graduate of Ohio State University and the University of Cincinnati College of Law, and a single mother with strong community ties, making her a low-flight risk. The judge set bond at $5,000 and issued a no-contact order, prohibiting communication between Sydney and her mother until further notice. In late December 2024, concern grew in a Miami Beach neighborhood when a boy was spotted crossing a busy street alone. A Good Samaritan called 911, and when police arrived, the boy led officers to his family's apartment on 15th Street. Inside, they found 2 girls and 2 boys living in conditions described as severely unfit. The girls and boys told police they hadn't eaten since the previous evening, and the oldest, a girl, explained that she was often left to care for her siblings. Upon inspection, officers noted the apartment had no electricity, no food, a clogged toilet filled with stagnant water, and no working stove. The boys and girls shared that their parents would eat separately and didn't regularly provide meals. Authorities arrested the parents, 33-year-old Azra Nikochevich and 40-year-old Sanel Kanovic, charging them with multiple counts of neglect. In court, the couple was released on bond and claimed financial hardship was the root cause of the situation. The boys and girls were placed in protective custody, and the investigation remains ongoing as officials assess the family's history. In Lorain, Ohio, authorities launched an investigation on August 21, 2023, after Officer Rick Braz responded to a call about a distressed dog at a home on Washington Avenue. The animal was found in a weakened state and appeared to have been left without proper care. A second young dog was later discovered dead at a neighboring property, reportedly removed by a neighbor while moving out. Both dogs showed signs of long-term neglect. The investigation led to charges against Amanda Pippins, then 35, and Morris Ellison, 37, for animal abandonment and cruelty to companion animals.
18 CRA 03059 and 3060, charges of cruelty to companion animals, a felony in the 5th degree. That's set today for preliminary hearing. Then is a related charge of abandoning animals, a misdemeanor in the 2nd degree. Mr. Nelson. Need that in writing. I assume you want the misdemeanor bound over with it. All right, so need a time waiver on that as well. Can I Bailiff Station, please? Waivers are accepted. Ms. Pippins, your cases are bound over to the grand jury for its consideration.
No objection to bond being continued.
And bond is continued. Any further, Mr. Nelson? Nothing further. Thank you, Judge. Thank you. Next case.
Following court proceedings, Pippins waived her right to a preliminary hearing and the case advanced to trial. On June 17, 2024, she was found guilty by Judge Raymond J. Ewers of 3 counts of cruelty and 1 count of abandonment after a 1-day bench trial. She was sentenced on July 24th to 1 year of community control, probation, and barred from owning companion animals for 3 years. In addition, she was ordered to pay $290 to the Friendship Animal Protective League and $447 in restitution to the Lorraine Animal Clinic. Pippins chose not to speak at sentencing. Her co-defendant, Ellison, had previously received a year of probation after pleading guilty in March 2024. In mid-December 2024, Pullman Police Chief Jake Opgenorth was placed on administrative leave after allegations of domestic violence and sexual assault surfaced. The complaint was filed by a woman who had previously worked with Opgenorth on the Pullman Police Advisory Committee. Following the report, the Washington State Patrol launched an investigation, and Commander Aaron Bressiers was named acting chief in Opgenorth's absence. On December 31st, during a scheduled court hearing in Whitman County, Judge Gary Leby reviewed the woman's petition for a civil protection order. Opgenorth's attorney requested a continuance to prepare a response, and the judge granted it, setting the next hearing for January 8, 2025. In the meantime, a temporary protection order remained in effect, and Opgenorth complied with an order to surrender his firearms. By February 2025, Judge Roger Sandberg ruled there was insufficient evidence to uphold the allegations. He noted inconsistencies in the accuser's testimony, particularly text messages that showed no signs of fear, and described the relationship as mutually emotionally charged rather than abusive. The court denied the protection order and dismissed the petition. Shortly after the ruling, Opgenorth resigned as Pullman's police chief, officially ending his tenure. In 1998, Jacksonville, Florida, was shaken when Maddie Clifton disappeared from her neighborhood. After a week-long search, police discovered her remains in the home of Joshua Phillips. He was arrested shortly afterward, and the community was left in disbelief. In 1999, Joshua was tried as an adult, convicted of first-degree murder, and sentenced to life in prison without the possibility of parole, as required by Florida law at the time. Years later, in 2012, the U.S. Supreme Court ruled that mandatory life sentences without parole for juveniles were unconstitutional. This decision led to many cases being revisited, including Joshua's. In 2017, he was resentenced. The judge upheld his life sentence, but allowed for a sentence review after 25 years, giving him the chance to seek a reduction in the future. By 2025, Joshua had served the required 25 years and requested a sentence review.
We are ready to call the case of Joshua Phillips. He is 60 on the court's calendar. He is here for a sentence review. The primary attorneys will be Bernie Delavan and Jay Plotkin, and we do have 3 family members that are on Zoom that would like to appear by Zoom.
All right, and I think we've got, yes, all right, everybody is in the Zoom room. All right, so we are here for sentence review.
Yes, Judge.
Correct? Okay. So tell me what is the status at this point?
Your Honor, we just were recently appointed, so I haven't had a chance to go through essentially all the files. So I think that maybe a couple months of a review date so we could have an idea. That's really all that I can say at this time.
Sure. And so are we thinking that we want to just maybe pass for 30 days or so and then come back and check in for a status as far as where we are?
Yes, Judge.
Okay, why don't we do that? And then we can talk about, once Mr. Beard, you've had an opportunity to delve into the case, we can talk about timing as far as, setting the sentence review.
Yes, Judge.
All right. So why don't we come back, how about Tuesday, July the 8th?
That's fine with the state, Your Honor.
All right, Mr. Beard?
Yes, Judge.
All right, we will set a status. We'll change that from a to be set until we get farther along into the process, and then we can put it back on for a to be set. But let's put us down as a status date on Tuesday, July the 8th.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Judge.
Thank you.
morning, Judge.
Good morning.
If we can next call the case of Robert Davis, case number 26 on the court's calendar. Juan and Arjona on behalf of the state.
All right, thank you. Case number 26, Robert Davis, who is out of custody.
During a hearing, his attorneys asked for additional time to prepare, and the judge scheduled a status update for July 8th to determine the next steps. Maddie's family publicly shared their opposition to any sentence reduction, saying the original decision should remain in place and emphasizing the lasting impact of the case on their lives. In late January 2023, the quiet Houston Heights neighborhood was shaken when the bodies of Dana Rystyle and James Gerald Martin III were discovered. Investigators revealed that the two men had been killed days apart. Rystyle was found inside a townhome, while Martin was discovered later in the trunk of his car. Authorities soon linked the case to a marijuana business that both men were connected to. As the investigation moved forward, detectives identified two prime suspects, Holy Fan and Jaidan Vudnguyen. Evidence suggested they had fled the country shortly after the case, eventually leading authorities to track them overseas. While efforts were underway to bring them back to face charges, another person became the focus of the investigation, 23-year-old Kathy Vu, Fan's girlfriend. Detectives learned that on the day of the murders, Kathy Vu purchased cleaning supplies, including bleach, towels, and trash bags. Witnesses and surveillance footage tied her to attempts to clean the crime scene, leading prosecutors to charge her with tampering with evidence. Court records confirmed that her role did not involve the killings themselves, but centered on trying to conceal what happened afterward. In March 2023, Kathy Vu appeared in court, where prosecutors argued that her actions showed a willingness to help cover up a serious crime.
Kathy Vu is charged with tampering with evidence. This case is assigned to the 262nd District Court. Ma'am, are you a U.S. citizen?
Yes.
You requesting a court-appointed lawyer?
Yes.
Are you requesting help to get your bail set?
Yes.
State, what is your position as it relates to bail?
The state recommends a $50,000 bond amount. We're opposed to a PR bond in this case. The state notes for the record, the defendant aided the co-defendants to conceal one of the crime scenes in a capital murder that they committed. Well, it was a multi-murder, and that they committed. The defendant purchased cleaning materials with the intent to assist in cleaning the crime scene in her garage. The defendant is a danger to the community. The state recommends the following bond conditions: no weapons or firearms, no drugs or alcohol, random urinalysis, surrender your passport and visa. Do not apply for any other passports or visas while this case is open. No contact with the family of the complainant, Dana Rystyle. No contact with the family of James Martin III. No contact with co-defendant Holy Fan. No contact with co-defendant Jaidan Wynn. 24-hour house arrest. Do not leave Harris County or its contiguous counties without court permission. Nothing further.
Public defender.
Requesting that bond be set at $10,000 personal. Ms. Wu is 23 years old. She is a lifelong resident of Houston. She's currently residing with her parents and her sister. She is also currently helping provide care for her grandmother, who is disabled. We are opposed to house arrest, as she is currently employed at Team Enterprises. She's been there for the last year. She's making about $4,000 a month. She has no prior convictions, and she's a no to the new violent criminal activity flag. That's all, Your Honor.
We're gonna set bail at $40,000. We're gonna order the following conditions of bail. The defendant's travel is restricted to the state of Texas. The defendant shall surrender her passport or any other travel documents to pretrial services. No drugs, no alcohol, no firearms.
The judge set her bond at $40,000 with strict conditions. She was placed on GPS monitoring, ordered to surrender her passport, avoid contact with the victims' families and co-defendants, and remain under house arrest unless approved otherwise by the court. As for Fan and Nguyen, authorities eventually extradited them back to the United States to face capital murder charges, while the investigation into Kathy Vu's involvement continued. In late 2024, Jacksonville Sheriff's Office, Corrections Officer Brad McNew intervened at a truck stop to assist a woman in distress. During the encounter, he was tragically shot and later died from his injuries. The community mourned the loss of the dedicated officer who had served for many years. The following day, law enforcement identified DeMaria Grant as the suspect and launched a multi-state search. He was apprehended in North Carolina and returned to Florida to face charges that included murder and firearm-related offenses. A local grand jury subsequently escalated the charge to first-degree murder, reflecting the seriousness of the alleged crime. As the case proceeded, prosecutors announced their intent to seek the death penalty, citing aggravating circumstances such as Grant's criminal history and the nature of the offense.
Yes, so Mr. Grant is present with his attorneys and the state. We're here for arraignment and initial plea conference. Ms. Schlacks, Mr. Bossing, good morning.
Good morning, Judge.
And good morning, Your Honor. Julie Schlacks and Michael Bosson appearing on behalf of Mr. Grant, who stands to my right. Your Honor, we are in receipt of initial discovery. Additionally, my client and I have discussed at length his constitutional right to a speedy trial based on the dates and the amount of work that we need to accomplish on his behalf. We will be waiving the speedy trial. However, we would request a trial date in 2026.
You want to set that today?
If we could, Your Honor, so
Okay.
that we know what we're looking for.
We can do that. Mr. Khalil, good morning.
Good morning, Your Honor.
What was the original speedy, or what is the original speedy trial date?
Judge, Mr. Grant is a prisoner from out of state, and because he's in custody status in North Carolina, he had to be brought through IAD. There's a 120-day speedy trial right from the day he hit Florida border, and so speedy trial runs on IAD on September 2nd.
Ms. Schlacks, do you agree that that is the actual speedy trial date?
Yes, Your Honor.
And Mr. Khalil, has discovery been tendered, provided?
It has been, Your Honor, both the original discovery and the supplemental discovery for the penalty phase. This may be an appropriate time, Your Honor, for me to file our notice formally.
I was going to ask you.
Your Honor, at this time, the state would be filing a notice of intent to seek the death penalty and a notice of aggravating circumstances pursuant to Florida Statutes 782.04 of Florida law. The defendant has been charged with first-degree murder, and the state intends to seek the death penalty, placing the defendant on notice pursuant to Florida Statutes 921-141 of the following aggravating circumstances we intend to prove at trial. One, that he committed a capital felony and that he was under sentence or imprisonment or placed on community control from another jurisdiction for a felony offense. And two, that the defendant had previously been convicted of another capital felony or a felony involving the threat or use of violence toward another person. We would also be requesting a statement in particular listing statutory and non-statutory mental mitigating circumstances at this time. In conjunction with our death penalty notice, we are also filing a notice classifying this defendant as a prisoner releasee reoffender on those charges which are not capital in nature. Pursuant to this and in conformity with 775082 Florida statutes, we'll seek to have the defendant sentenced to life in prison if found guilty of a lesser included offense as to count 1 and to 5 years in Florida State Prison as a conviction for the aggravated assault charge on Officer McNew. The other charges are not prison releasee eligible. However, if necessary, the defendant does qualify as a habitual violent felony offender, and we'll be filing that notice if necessary after trial.
Thank you. Thank you. Is there a state offer in the case?
State's offering the penalty, Your Honor.
Okay. And Ms. Schlacks, are you ready for me to have a colloquy with Mr. Grant about the speedy trial issue?
Yes, Your Honor.
And have you filed a written waiver?
I have begun executing that right now. My client is affixing his signature right now.
And while they're doing that, Mr. Khalil, you heard the defense ask for a 2026 trial date. What's the state's position on that?
Your Honor, I have no objection to setting the case for trial whenever the court has time available. The only thing that I notified Ms. Schlacks in regards to is I have another case of a capital nature, which there's been some tentative discussions in front of Judge Kite to set that case beginning in January of 2026, and we anticipate that if the case does go to trial at that point in time, it would last the remainder of January and probably the entire month of February. So with that understanding, the state would be prepared to either set this case for trial mid to end of April or beginning of May, would be an appropriate time for it.
And I would suggest perhaps early April.
Okay, and we'll do that in just one moment. Mr. Grant, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. Your name's DeMaria Grant. And that's your waiver on this, or your signature on this unlimited waiver of speedy trial?
Yes.
You went over that with your attorney?
Yes.
Any questions about it?
No.
All right, the court will sign it as well. All right, Madam Clerk, you can have that.
Your Honor, Mr. Mizrahi just informed me that apparently Judge Kite is looking to potentially move that other case until April. So if the court wants to set the case in January of 2026.
Well, is that reasonably solid information, or? Why don't we do this? Why don't we set our standard pretrial date? You all get together, figure out your schedules, and then we'll come back and we'll set the trial date at the next court date.
That should be good, Your Honor. I believe our next court date is first week of June. Is that accurate, Mr. Mizrahi?
You talking about on the other case?
Yeah.
Yeah.
At his court appearance, Grant pleaded not guilty and voluntarily waived his right to a speedy trial. His legal team requested the trial be scheduled for 2026 to allow adequate preparation. During the same period, Michaela Huggins, the woman who was present at the scene, pleaded guilty to accessory after the fact and awaited sentencing. This case now stands in the pretrial phase, with both sides preparing for a trial set to unfold in the coming year. On July 3rd, 2015, Crystal Rogers spent what seemed like a normal day with her family, unaware it would be her last. Later that evening, she was reported missing after failing to return home. Her car was found abandoned with her belongings inside, but there was no sign of her. Months later, she was declared dead, though her body has never been found. Investigators eventually focused on multiple suspects, including Brooks Hoke, Crystal's boyfriend, and others linked to him. Among them was Steve Lawson, accused of helping plan the crime and cover it up. The prosecution argued that Lawson knew about the plan to kill Crystal and helped conceal evidence afterward. After years of investigation, the case finally went to trial in May 2025. On May 30th, a jury found Steve Lawson guilty of conspiracy to commit murder and tampering with physical evidence. The jury recommended 17 years for conspiracy and 5 years for evidence tampering, to run at the same time for a total of 17 years. At the sentencing hearing, Crystal's family gave emotional statements.
For Crystal, we're here for you too. We came out to see the court pass final sentencing down to you today. Your last farewell before you go off to spend a very long time in prison, which I hope is the worst experience you can ever experience in a prison. Hopefully you'll spend the rest of your life there. I could stand up here and go on about what a worthless, despicable, pitiful, thoughtless, gutless person you are, but I really don't have to say what everyone already knows, but that's the life you chose. On July 3rd, 2015, I imagine Crystal woke up thinking it was just going to be another ordinary day for her, running errands, spending time with her kids, and getting them places they needed to be, like she did every day. Later that day, believing she was going on a special date with Brooks Hout, she was unaware that it would be the last day her children, her mother, her dad, Casey, and her sister, Brooke, would ever hear her voice or see her again. But you knew that. You knew all about that special date. Because you, Joey Lawson, your son, and Brooks Hout had a plan in place for the murder of Crystal Rogers and to dispose of her and her car. We all make choices in our life, and it looks like you made a lot of bad ones in yours. In July 2015, you made a choice to be a part of planning the murder of my niece, Crystal Rogers. You could have prevented all of this from happening if you'd just gone to police and done the right thing. If you had done that, I believe Crystal would still be here today, and so would my brother Tommy Ballard. But no, you couldn't do that because you wanted the drywall works from Brooks Hout, and that's all this young lady's life was worth, and maybe just a little cash. A lot of people search for Crystal all the time, many searches, but nobody searched for her like her dad, Tommy Ballard. And you knew Tommy was a good man, and you knew he was out searching every day looking for his daughter. But you didn't care. It didn't make anything to you, didn't mean anything to you. And he searched for her every day, every night, until the day he died. And you knew it. You didn't say anything about it. You knew what happened. Again, you could have prevented it all. Crystal still would have been here, and I believe Tommy Ballard would have still been here. But you didn't care about anyone but yourself. You have no remorse, no feelings about it. I don't believe you're sorry about it. The only thing you're sorry about is getting caught and going to prison. You had many times you could have made the right choice, but never did. Crystal was a good person. She wasn't on drugs, and she certainly wasn't an alcoholic. She never did anything to anybody, and especially she never did anything to you. Crystal was a beautiful, loving mother of 5 children. She was a daughter, a sister, an aunt, a granddaughter, a niece, and never deserved for her life to end the way it did. We'll always remember that beautiful smile, and that's something nobody can ever take away from us. I hope the court gives you the maximum sentence possible, though it will never bring Crystal back and never be enough.
Her uncle, Mike Ballard, said Lawson could have stopped the crime or told authorities the truth, but chose silence, which cost not only Crystal's life, but also the life of her father, Tommy Ballard, who was shot and killed while searching for her years later.
No, Your Honor.
At this time, in conformity with the jury's verdict, it is the sentence of the court that Mr. Lawson be confined in a penal institution, therein to remain for a period of 17 years upon his conviction to conspiracy to commit murder, 5 years for tampering with physical evidence. It's a further order of this court, all times shall run together or concurrently for a total sentence of 17 years. Also, for the record, the court would note that at any request for probation or conditional discharge, the court believes he's statutorily precluded from asking for that. But even if not, the court finds that to grant probation or conditional discharge would unduly depreciate the seriousness of this matter. I will be signing a judgment here today After that judgment has been entered by the clerk's office, the clerk is going to send copies to both sides, and then that can be appealed if he wishes to do so.
Yes, sir.
Anything else we need to take up at this time, counsel?
Let me have some comments. Nothing, but I'd like to approach on just an administrative matter, but it has nothing to do with.
Sure, come on.
So it won't take long.
That concludes the hearing. Good luck to everyone.
Lawson showed little reaction as the judge denied his request for a new trial and pronounced the sentence 17 years in prison. The judge noted probation was not appropriate given the seriousness of the case. Crystal's family vowed to attend Lawson's parole hearings to ensure he serves the maximum time and again urged him to reveal where Crystal's remains are so the family could have closure. This sentencing marked the first conviction in the decade-long mystery surrounding Crystal Rogers' disappearance, with more trials expected for the other suspects in the case. In June 2024, Oakland County Deputy Brad Reckling, a 9-year veteran of the Sheriff's Office, was working with a task force investigating stolen vehicles in Detroit. During one of these operations, he was fatally shot, leaving behind his family and colleagues who described him as a dedicated and courageous officer. As the investigation unfolded, authorities discovered a multi-county auto theft ring that had been active since late 2023. 3 suspects were identified and arrested, each facing charges tied to the criminal enterprise, carjackings, firearms offenses, and in one case, the murder of Deputy Reckling. The first suspect, Raymond DeBose, was charged directly with the murder.
The court is going to abide by the sentence agreement that you entered into. Please stand, sir. And as to the conviction of homicide, murder of a peace corrections officer, the court does sentence you in pursuant to the sentence agreement to 33 to 60 years in the Michigan Department of Corrections. And with respect to the count of weapons, felony firearm, the court does sentence you to the statutory mandatory 2 years, which must be served preceding and consecutive to the homicide murder of a peace corrections officer. There is jail credit that will be attributed to the weapons felony firearm. That jail credit will be 267 days. A motion was already made from the people to dismiss the remaining counts. Pursuant to that sentence agreement and that motion, those remaining counts will be dismissed. You must pay a crime victim assessment fee in the amount of $130. You must pay court costs in the amount of $600. You must pay $136 in state costs. You may file an application for leave to appeal your conviction and sentence. And if you choose to do so, you must do so within 42 days. If you cannot afford an attorney, the court will appoint an attorney.
In August 2025, after pleading guilty to first-degree murder of a police officer and a felony firearm charge, he was sentenced to 33 to 60 years in prison, plus an additional 2 years for the firearm offense.
Corrections to the body of the report?
No, Your Honor.
And with respect to the guidelines?
With respect to the guidelines, starting with the first one, the carjacking offense, no changes to the PRVs. The only change that we have are to the offense variables. That is OV 12 should be 10 points. I did discuss that with Mr. Sinclair. He's in agreement. The total OV level should be 55. The OV level stays the same at 3. The guideline minimum range does not change.
All right, so OV 12, instead of 1, it should be 10.
Correct.
making the total $55. OV level 3. Okay, and I think Mr. Sinclair already placed on the record that he had no objections to these changes, correct?
Yes, ma'am.
All right, please continue.
With regards to the criminal enterprise charge, Your Honor, OV1 is 15, which is correct, but OV3 should be 0. If the court recalls, we had this discussion with regards to the third defendant on this case, Kareem Moore. The people are in agreement that OV3 should be 0 and not 100. OV12 should be 10. OV13 should be 25. Bringing down the OV level to 80. Or the total OVs to 80. The OV level stays the same, and the guideline minimum range stays the same as well.
And again, just, I know you said it, but just for the record again, no objection, correct?
Correct.
Please continue.
With regards to the third count, the stolen property, receiving and concealing a motor vehicle, PRVs are correct. The OVs, OV12 should be 10. OV13 should be 25, making the total OVs 50. The OV level should be 5. It does change the guideline minimum range to 14 to 29.
No objection?
No, ma'am.
Right, those changes will be made. Any other changes with respect to the guidelines, or is that it?
That's it, Judge.
And any victim impact statements to be made today?
Not today, Judge.
Anything else on behalf of the people?
Your Honor, on behalf of the people, I do want to thank Bradley Reckling's family, friends, colleagues, his widow, Jackie Reckling, who signed off on this sentence agreement as entered into by the people and the defense. I'd also like to thank the Homicide Task Force for their thorough investigation of this case. While this particular defendant was not charged with the murder of Bradley Reckling, he was involved, charged, and convicted of conducting a criminal enterprise that involved carjackings, stolen motor vehicles, and guns, which ultimately led to the culmination in, or ended with, the murder of Bradley Reckling, which he made the ultimate sacrifice for. And I think that needs to be recognized in this case. With that being said, I would ask that you adopt the sentence agreement as entered into by the people in the defense, and when it is appropriate, the people would move to dismiss the appropriate counts as indicated on the plea agreement.
Thank you. On behalf of Mr. Goins.
Yes, ma'am. So our thoughts and prayers are with the individuals and the families impacted by the actions that bring us to court today. Mr. Goins has accepted his portion of responsibility for those actions, asking the court to adopt the sentence agreement that we arrive at sentencing today with, and of course no objection to the dismissal of the counts that are also part of the sentence agreement.
Thank you for that, Mr. Sinclair. Mr. Goins, today is the day and time set for sentencing. Is there anything that you would like to say to the court before the court imposes a sentence?
No, Your Honor.
All right.
The second suspect, Marquis Goins, admitted to participating in the criminal enterprise, committing carjacking, and concealing stolen property.
Please stand, sir. The court is going to abide by the sentence agreement you entered into with the people of the state of Michigan, sentencing you as follows. As to count 4, receiving and concealing a stolen property or motor vehicle, the court sentences you to 1 to 5 years in the Michigan Department of carjacking. The court sentences you to 8 to 30 years in the Michigan Department of Corrections, which would be consecutive to count 14, weapons, felony, firearm. 2 years, which must be served consecutive to and preceding count 13, which is the carjacking. The court also sentences you for count 15, conducting a criminal enterprise, 5 to 20 years in the Michigan Department of Corrections. Is there a motion from the people?
There is a motion, Your Honor, pursuant to the sentence agreement, the people would move to dismiss counts 3, 5, 6, 7, 8, 9, 11, and 12.
Any objection?
None, Judge.
Counts 3, 5, 6, 7, 8, 9, 11, and 12 will be dismissed pursuant to the sentence agreement you entered into with the people of the state of Michigan. You must pay a crime victim assessment fee in the amount of $130. You must pay court costs in the amount of $300. You must pay $272 in state costs. You may file an application for leave to appeal your conviction and sentence. And if you choose to do so, you must do so within 42 days. If you cannot afford an attorney.
In July 2025, he was sentenced to 8 to 30 years for carjacking, 2 years for the weapons charge to run consecutively, 5 to 20 years for the criminal enterprise, and 1 to 5 years for concealing a stolen vehicle. The third suspect, Kareem Moore, pleaded guilty earlier in 2025. In May, he received a combined sentence of 3 to 20 years for the criminal enterprise, 2 years for the firearms offense, and 1 to 5 years for concealing stolen property. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.